Hi, good evening. It's Solicitor Ronald Onyango here. Thank you all for joining me today. I seek to today discuss the changes that were proposed on the 20th of November 2025 under the Fair Pathway uh, to Settlement. It is my hope that obviously this will create an illustrative opportunity for those who want to understand what is proposed, which is still under the reforms, and how it will impact on the those who have not received their indefinite leave to remain. Looking at the proposal known as uh, the fair pathway to settlement, I need to looking at how we can one can understand the proposed consultation. Um, the government announced this as by the Secretary of State Shaban Mahmood made this announcement on the 20th, and this is going to go a long way to help those who still wish to understand this particular settlement, as it will help them to be able to fill in the survey and inevitably be able to make the required contribution. Now, we know that the government's objective is under the reform is planning to create these reforms, which was announced in 2025. The government actually aims to restrict those who it's going to who are allowed to come to the UK or remain and settle. And this obviously goes across various visas and asylum seekers and family reunion basis and also refugee protection. It's known that the reforms actually is prioritizing domestic labor first, and then it will also raise a skills threshold for work visas, which is actually going to limit social support and the residency eligibility for asylum seekers, and also introduction of stricter removal rules for those who are arriving via unauthorized routes. Uh, the new rules essentially under the reforms looks at the work visas would only be granted for applicants who meet higher skills and the salary thresholds, essentially at a graduate level roles, rather than a broader spectrum of lower skills and shortage occupation skills. So we're just looking at who this actually is targeting for. Also, employers who are seeking to employ foreign workers for lower skills will need to demonstrate a clear labor market tests and shortages, essentially evidence that there's a shortage, and also commit to train domestic staff, clearly shifting the default from importing labor to using local or labor staff. We also know that asylum seekers and refugees would receive far less um, uh, 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 certainty over long-term stay or permanent residence. The new system moves towards limiting time, limiting protection rather than automatic routes to settlement, with residency and the right to settlement significantly being curtailed for many. We also know that the proposals looked at family reunifications and also access to welfare and pathways to permanent settlement, whereby this would face tighter restrictions and potentially leaving many asylum seekers in a prolonged and uncertain limbo. We know that the consultation uh, seeks views on options that can be applied to reduce the forecast volumes at present of 1.6 million between 2026 and 2030 and 450,000 in 2028 to achieve the following. The government is trying to increase the baseline qualifying the baseline qualifying period for settlement to 10 years. Also increasing the qualifying period for settlement to 15 years for those skilled worker routes in a role which have got RQF below level 6, which is equivalent to a bachelor's degree. There's also going to be implementing the no recourse to public funds condition on settlement. After the consultation, we know that the government will set out its preferred options or a combination of various options to achieve this, which will then be determined. Um, we understand that this is going to be dealt with under what's known as principle of earned settlement. Essentially, now it's no longer, we know that the government has said that citizenship is no longer a right, but it's a privilege. So therefore, one is expected to earn settlement. The government says that the principle is aimed at, it will recognize that the value of long-term contribution to the UK, rather than granting settlement after a fixed period, which has been the case. The approach ensures that the individuals will need to demonstrate a sustained commitment through their work, community involvement, or other meaningful contributions before they can be granted settlement status. The new model also will have what's known as accelerators, which are factors that will increase the standard qualifying period for settlement to 10 years. Or however, you may also have the opportunity to have decelerators, which would reduce the period based on their contribution to the UK economy and the society at large. The proposal that earned settlement system will be based on a time adjustment basis of accelerators and decelerators, built on the four core pillars, and which are designed to ensure that applicants make a meaningful and contribution to the UK society and meet clear, measurable standards. Looking at all these factors, the primary core factors that will be determined under the earned settlement are as follows. We have the character and stability, which essentially provides for the refusal of an application where the core requirements relating to the character and the conduct, including criminal record, compliance with the immigration requirements, and considerations pertaining to the public good are met. Here, the applicant has no, obviously, need to show that they do not have a current litigation, for instance, on NHS or tax or other government debt. And then it will also be mandatory to meet such requirement that there will be no ability to trade with other consideration to determine the qualifying period. This will be mandatory requirements which have to be met. It is known that the expectation is that one should not be able to settle with a criminal record, unlike before, which may have been slightly different. The other core pillar, which should be considered, is the integration element, whereby one will need to ensure that the applicant demonstrates a meaningful engagement within the British society. It's important that they be able to show that they've actually integrated, unlike before. And the third pillar is the contribution element. This is whereby there will be a system which rewards individuals who have made a sustained and measurable economic contribution to the UK, on the principle that they are that any accelerating factors accelerating to the path to settlement should be earned through active participation in the economy. And last core pillar is the residence, that the path will recognize lawful continuous residence in the UK, where individuals will need to individual will not, however, normally qualify on the basis of residence alone. So this will be a combination of the four factors that will be taken into account that will be used to determine this. We also know that under the as a summary proposal overview of the earned settlement and how this may impact, and the earned settlement principle, this will be based on time adjustment factors, as I mentioned, as of the accelerators and decelerators model built on the four pillars just referred to. And the other factor is that the default qualifying period of settlement will be increased from the current 5 years to 10 years, with exception for certain groups or individuals. Those routes, for example, the skilled worker routes that currently lead to settlement after 5 years continuous stay, will cease to do so and will default to a qualifying period of 10 years, except where an earned reduction on the basis of contribution or integration applies, the decelerating factors. Also, we know that there will be no more separate long residence route. And a consequence is that unlike before, where this previously existed, one could have a separate long residence. This will also be removed. And on the non-compliance and negative contribution factors, a person's pathway to settlement will also depend on their history of compliance with immigration rules. So more importantly, now people need to make sure that they actually abide and comply with immigration rules. This may also affect both their qualifying period for settlement and whether an application for settlement will be considered at all. This will impact the pathways to settlement, and even where breaches do not have the consequence of resulting in the outright refusal of an application, they should in the they should result in them being the qualifying period being extended. And on the summary also we have overstays, where it was also where it was judged that an overstaying breach should not lead to outright refusal. It would nevertheless cause the qualifying period for the settlement to be increased. Consequently, consulting on whether this should be, the government is consulting on whether this should be on a 5-year period, 10 years, or 15-year period, or even 20 is still yet to be determined. I shall be proceeding with part 2 next time. Please, if you haven't followed us on this, where I shall be highlighting the other factors, please do subscribe and follow us on this as we discuss the other factors under the proposed summary. Thank you very much. If you have any more questions, you can also feel free to send me a message for clarification.